as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So if I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based on my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, and then go into something about then you may not use the guilty plea or verdict, whichever.
All right, well, I
against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
I can't. I don't want either one. Sorry.
I don't want either one. And
I'm
like
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error. But I would prefer not to do that, because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I still maintain my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute so we may have
And
a split?
y'all don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today. Yes, ma'am. Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right. How about announce, and then if they want to huddle, they can huddle.
So, and good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our third witness this morning. I know we were, Ms. Abbas and I were supposed to speak very briefly. After they're huddling, we can have just 2 minutes to speak.
Well, I may have them huddle later,
Okay.
because the Wooney Lee stuff's more pressing, because you can you can tender the conviction, you know, in any order.
Yes, Your Honor.
So on the Wooney Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him, and I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic. Pick one up, maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell, and yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that? Did y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me. At the very end of the day, I had inquired to the court, said, discuss what's going to be the order tomorrow, and I said, well, Mr. Mitchell, Mr. Uten, checking. Mr. Kokomo took a look, and before lunch, what was represented to the court said, who are we going to get to? And they said, we may not get to him today. So
that was before lunch.
That was before lunch, and then we came back in, and everything was published.
And everybody not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back. He didn't want to speak with us. That's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch, and we didn't call Mitchell. And the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been permitted
There has not.
or agreed to by any of the parties during the trial of this case, at least at the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, that it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's. I can't promise you my memory is 100% accurate, and I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you, on the record, asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying when are we getting to Mitchell and Uten.
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything first.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him if that will solve the issue.
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
Okay. And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling him.
All right. Well, then that's even more of a record against your recollection.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence. Reason for me to ask.
Okay, Squire, we caught this part earlier. We're gonna get on back
You're
into
saying you
courtroom.
pointed towards the holding cell doors.
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
We sent it. Sent the email on yesterday at 9 a.m., Your Honor.
To whom?
Well, you know what? I don't think Miss Percival is on it, so let me forward it to Miss Percival. I'm sorry.
What were the warrants you took out
for murder.
person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Uten, the victim, anyone in the car, was Mariah. She's the only person who said they knew one another, right?
That you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Uten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So, Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you, was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Uten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person or I have a problem with this, nothing.
They who?
Mr. Mitchell and Mr. Uten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they're correct, yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I remember.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
He was described as being tall, I believe. Just
All right.
a second. Let me double check it. Just a second.
And I can get you a transcript of your interview with Mr. Uten if that further helps too.
I bet you can. Let's see. Yes.
Okay. So Mr. 762 is tall, and based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 762, right? Page 18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh.
Okay, wow. You got more than me. Okay, I see what you're referring to, yes.
Yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I wrote, yes.
Gotcha. All right, so we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes.
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
There were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who would have been there responding?
They were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Uten whether they had guns, correct?
Yes.
They both had guns, right?
Yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Uten, I don't recall ever asking that specific question.
All right. You didn't ask him what kind of a gun he had, right?
I don't recall asking him.
You asked him what happened to it, though, later, right?
Yes.
And he indicated to you that you should...
All of this is hearsay. What Mr. Whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Fulton was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Uten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You, at some point, had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because a teenager is better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive, no ma'am.
No. No deep dive. You didn't look at them.
Say it again?
No deep dive. I mean, you did not look at them, right?
I don't recall if I did, yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you learned that at some point he said he did, right? Or they did.
Yes, I did hear that, yes.
Thank you, Detective.
Oh, you're welcome. You didn't get this stuff back?
Are there
That's all yours. You're welcome.
other defense counsel with questions for this witness?
Good morning, Detective Hogan.
Take the time. Good morning. Good morning.
We've met before, but my name's Max Shard. I represent Shannon Stillwell, okay?
Okay.
All right, and the case that we're talking today, does not involve Shannon Stillwell at all, does it?
Not that I know of, no.
Okay. I just wanted to ask you one question on cross. You were asked about testing a car, the inside of a car for gunshot residue.
Right, yeah.
And you responded that it would not make any sense to do so unless a gun was shot from that car, correct?
That would be the most obvious reason to do so, yes.
Okay,
Test
so
for that.
if a gun is shot from inside a car, if your investigation leads you to believe that a gun was shot from inside a car, you certainly would test for gunshot residue, correct?
If there was any question that a gun was used inside the car, so if there was an allegation that it was, and
Yep.
there was reason to believe that it wasn't, we needed to prove that a gun was used in the car, then certainly we should process inside the car for gunshot residue.
Okay, when you say process inside the car for gunshot residue, what does that mean?
Well, we asked the ID unit. I've watched them do it several times. They have a Q-tip, and they swab areas, and they preserve that Q-tip, which gets sent to the GPI crime lab. And then they do their analysis, their whiz bank stuff over there to say if there's any presence of gunpowder, I guess is what it is.
And we're talking about microscopic particles,
Yeah,
right?
if you shoot a weapon anywhere, if somebody shot in here, the residue would be however tiny, microscopic, but it would be here on everybody, everywhere. Yeah,
It would go all over.
yeah, it goes everywhere.
Okay, and you would ask the collection team, we'll say, to the crime scene technicians, I guess is the formal term, correct?
Yes.
You would ask them to collect from different areas within the car.
That's correct.
Are there any specific areas that you would have them focus on?
I generally let them do their job. They know more about that stuff than me. I ask them to process it, and I allow them to do it.
Okay.
So wherever areas they are. Another, the GBI has been a little more stringent on their testing of that. They're getting away from gunshot residue because of the fact it goes everywhere. It doesn't really prove anything.
Okay, so the concern when they're going away from it is not that it gives false negatives, but it gives false positives.
Right. So, for example, if you're a gunshot victim, you're obviously a gunshot victim. Guys that in the past I know have tried to test them for gunshot residue. Well, that's kind of silly because they are a gunshot victim. They're going to have gunshot residue on them. Also, the fact that if they're in a room such as this or other people, and somebody shoots, and then that person gets away, but somebody else is alleged to be the shooter. Well, if he was in the same room, he's going to have gunshot residue on him as well because it goes everywhere.
So it sounds like what you're saying, if you get a positive result from gunshot residue, it may be unreliable for proving what you're intending it to prove.
You don't necessarily have to be the shooter if you were in the room when the shot went off.
But if you get it, but from what I'm understanding, if you get a negative, that's still a reliable result. It's just the positives can mean different things.
Yes.
All right, great. And in your experience at times, you said you defer to the experts on the collection method. Have you known them to remove different parts of a car for further testing for gunshot residue?
Yes. Oh.
Sustained.
I can approach it. It is going to be relevant.
All right, I'll give you some.
And I'm just going to ask one more question. Is one of those parts that the experts remove at times the headliner of the car?
Yes.
Okay. Thank you. No further questions.
You're welcome.
Any other defense? Go ahead.
Good morning.
Good morning, Mr. Steele.
How are you?
I'm great. Thank you.
I'd like to ask you, in your work, have you ever had the need or the opportunity to ask for and secure surveillance cameras from businesses?
Several occasions, yes.
Okay. Can you tell the ladies and gentlemen jury, in your experience, have you ever had a surveillance camera operation where it would be a specific period of time that was captured, the images were captured by the surveillance camera?
Sure. Every system's different. There are some, from my experience, some common denominators. Most surveillance systems capture a certain period of time. It's generally around 2 weeks. And after those 2 weeks time period, it stops. You can kind of imagine that you're shoving the video into a tube, and as it comes out, there's just so much space to capture and to maintain. So as you capture more video, it starts falling off the backside after 2 weeks. So for example, if 3 weeks ago there was a crime that we became aware of, and we needed to try to get the video, we call if it's past that 2 week time period, the video is no longer accessible. It's been deleted. It's been overwritten and it's gone.
So in your example about the 3 weeks, so a video can hold up to 2 weeks of information, is what you're telling the jurors in our example.
It's kind of a general rule, Brian. But there are systems that capture and they keep them for longer periods of time. But those are expensive to maintain, and that's pretty rare that we have. But they're out there.
So if, just hypothetically, if we start on day one and the surveillance equipment can hold 2 weeks, so on day 14, from day 1 to day 14, it's all there if it's all working correctly. That's what I hear you say.
Yes.
I'm going to object to relevance.
It goes back. Now, on day 15, so day 14 ends, now it's day 15. Are you telling the jury that in your experience, day 1 is now gone, so now we'd have from day 2 to day 15?
That's my experience, yes.
Okay. Have you ever, tell the ladies and gentlemen jury, on day 15, so day 15 starts, all day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 are gone?
Without a catastrophic failure of the system, I have never heard of that. No.
Thank you. Thank you, Your Honor.
Anybody else? No question. All right, redirect.
Detective Hogan, do you recall Ms. Abbasi asking you about your interview with Ms. Smith and how she, I guess, about how she described the long gun? Remember her asking you about that?
Yes.
Do you remember her specifically asking you about the use of the term rifle?
Yes.
And do you recall, based on your interview, Ms. Smith was only able to describe the gun as a long gun, correct?
Yes, she was not well versed in.
You can answer the question.
She was not well versed in guns. She was using pretty generic terms. Yes.
Now, I want to bring your attention to something that Ms. Abbasi just, one of her last questions, she talked to you about how Ms. Smith just kind of described or said how Mr. Ryan or somebody would know any other parties. Remember her asking you about that?
Yes.
And do you remember what Ms. Smith's response was, or conversation with you was about how Mr. Ryan knew Mr. Mitchell?
Your Honor, I'm going to object to this. That's not the question. The question was whether anyone besides Ms. Smith described him knowing one another.
I think she opened the door as to how.
Go ahead.
Do you recall?
Of how Ms. Smith knew Mr. Mitchell?
No, about how the question that Ms. Abbasi asked you was about how Ms. Smith described to you and talked to you about how Mr. Ryan knew Mr. Mitchell. Do you remember having that conversation with you? And that if looking at a copy of the transcript would help refresh your recollection of your interview with Ms. Smith.
Sure, man.
I want to direct your attention to page 93, where the minute marker is 2:18:21.
And Your Honor, I'm going to object to this at this being hearsay. We're not impeaching her.
What are you going to ask?
What she said. I mean, that counsel opened the doors when she asked the question as it related to the conversation that the detective had with Ms. Smith about how the parties knew each other.
So are you refreshing his recollection as to what you said about it?
That's correct, Judge.
I'm going to permit it.
Your Honor, the question was about whether anyone else described them knowing one another, not what she said, how they knew each other.
All right. I'm going to allow it.
I can ask the question again, Detective, after you've reviewed.
Yeah, you're going to have to. Give me a second. Okay, I'm with you.
Okay. So in reviewing page 93 of the transcript of the interview with Ms. Smith, can you tell the jurors, is your recollection refreshed as to what Ms. Smith indicated or told you about how Lil Rod or Rod and Mr. Mitchell were familiar or knew each other?
Yes.
And can you tell the jurors, what did she tell you?
She said that little Rod told her that BJ took his gun, Mitchell took his gun.
Now, I also want to talk to you about a question that Ms. Abbasi asked you as it related to describing, as you spoke with Ms. Smith, that this was an ambush. Do you remember her asking you about that, using the term ambush?
I remember using that term. Can you tell me where to look? I don't recall it in the interview.
No, what I'm asking you is during your cross-examination, Ms. Abbasi had asked you some questions as it related to you describing or using the term ambush. Do you remember that?
Yes.
And can you tell the jurors or describe to the jurors why your investigation and through your investigation, tell the jurors why you called it an ambush?
It wasn't a robbery. The shooters never approached the vehicle. They were lured to a certain spot.
Your Honor, I'm going to object to him testifying as these are actual facts. He can say what he investigated, what he did or did not.
Sustained.
So I'll rephrase the question. Can you tell the jurors what in your investigation drew you to characterize or classify this shooting as an ambush?
It wasn't telegraphed. It was sudden. They snuck up from behind and...
I'm going to object again.
Sustained.
Same thing.
I'll move on. I want to put up State's Exhibit 10NN. Well, before I move on, and as she's putting up the photograph, based on you said you were in homicide for how many years?
10 years.
And you said you've worked in law enforcement since you said 1987.
Yes.
How many years is that?
A lot. 36, 37.
Okay. And can you tell the jurors based on your training and your number of years of experience. Have you, well, let me ask you this. Before you worked in homicide, did you work cases that also involved shootings, but no deaths?
Yes.
And can you tell the jurors, based on your number of years of experience and your number of cases that you've worked that involve shootings, what the term ambush means in relation to your investigations?
Something that's sudden, unexpected, where the victim in that situation is pinched in or in a small area that he's hard to get out of or he can't get out of. Sit and duck kind of a thing.
Okay. Now, you see the photograph in State's Exhibit 10NN?
Yes.
Can you tell the jurors, is that drawn to scale?
No.
And can you tell the jurors, did you intend that photograph to, or that drawing to be an exact replica of the scene?
No.
What was the purpose of using State's Exhibit, or drawing State's Exhibit 10NN?
It was just a way to kind of demonstrate what my theory was at the time when I created it.
And in your drawing, can you, well, I want to take you to State's Exhibit 18NN. Now, in State's Exhibit 18NN, can you tell the jurors in this photo and your actually being at the scene, can you tell the jurors how many breezeways are in the building that we're looking in front of right there?
Just one.
Okay. And in your drawing, how many breezeways were depicted in your not to scale drawing?
One.
Okay. And I want to show you State's Exhibit, I think it's 17NN. Yes. So do you see 17NN?
Yes.
Can you point to the jurors in this different angle of the building, where on this exhibit would the breezeway be? Would it be on the left-hand side, the right-hand side?
The sidewalk leads to it's off camera right here.
Okay, and then you see where on the right-hand side it states that it's 17 and the building kind of intersects or meets with another building. You see that?
This here?
Yes.
Yes.
And I want to show you State's Exhibit 59NN. Now, in this exhibit's 59NN, can you show the jurors where in that exhibit are the shell casings that you described previously that were found in that area of the crime scene?
They're indicated with the yellow placards.
Okay. And in comparison to or in relation to your not to scale drawing in State's Exhibit 10NN, did you place red dots on that photograph to depict something similar?
Yes.
Okay. And when you were putting the red dots on State's Exhibit 10NN, did you put exactly 15, or what were the dots there to represent?
They were there to represent the shell casings.
Okay. And were they there to represent the shell casings, the general area where they were found.
That's correct.
And was in reviewing your drawing, States Exhibit 10 and N, is where you generally put the red dots consistent with where we saw the actual shell casings found on the crime scene?
When I created the drawing, that's where I thought they were, yes.
Now, while on scene, let me ask you this question. How long was law enforcement generally, if you know, on scene that night or that early morning at the scene of the shooting?
3 to 4 hours, maybe a little longer, I guess.
And in the time that you were there, did anyone approach you who had called 911 to speak?
No.
Now, Ms. Abbasi asked you some questions as it relates to how many shooters Ms. Smith described. You remember that?
Yes.
Can you tell the jurors, after the initial part of your interview that you described earlier with Ms. Smith, did she consistently, after you confronted her with the physical evidence, describe the fact that there were always 2 shooters?
Yes.
And can you tell the jurors, during that interview, was it you or was it her who placed nicknames in relations to those 2 shooters?
It was her.
And before Ms. Smith told you that, did you have any idea of the nicknames of who she said the 2 shooters were?
I did not.
And do you remember during that interview Ms. Smith describing Mr. Uten and Mr. Mitchell running from the blue Charger?
Yes.
And can you tell the jurors, at any point during her interview, did she describe to you that as they were running?
Your Honor, I'm going to object to this as leading.
Sustained.
I'll withdraw the question. But I do want to ask you, Ms. Abbasi asked you about, let me ask you this question. Through your number of years as a law enforcement officer, have you received a number of trainings as it relates to firearms?
Yes.
And through your work with the Atlanta Police Department and the other law enforcement agencies you worked with before that, can you tell the jurors, are you familiar with a revolver?
Yes.
Okay. Can you tell the jurors, how is a revolver different from, let's say, a 9mm handgun or pistol?
Namely, there's several big differences between a 9mm semi-automatic handgun and a revolver. Revolver is self-contained. It has a cylinder that's in the middle of the gun. When you, it's either double or single action. If it's a double action, when you pull the trigger, it rotates the cylinder and at the same time pulls the hammer back. When the hammer falls as the next shell casing comes up into the barrel, it hits the firing pin and it shoots the projectile out of the front of the weapon. Biggest difference there is there's no shell casings that come out. The operator can open the weapon and dump the shell casings out, but it doesn't automatically eject them. Semi-automatic, 9mm, when you pull the trigger, it's a very similar action, except there's no cylinder. There's a spring that when you pull the slide back, a shell or a projectile with a shell is lifted slightly up from the clip. There's a clip that catches the projectile and puts it in the barrel ready to shoot. And then when you pull the trigger, a firing pin goes forward, projectile goes out the front, the slide automatically from gas pressure gets pushed backwards. The next shell casing is lifted up by a spring. It ejects the shell casing out, usually to the right, and then it goes forward, picks up the next projectile and shell casing to go into the barrel, ready to shoot again.
Okay. Now, in the vehicle, the blue Charger, can you tell the jurors were the defects that you observed in the car in the front or in the back of the vehicle?
Back and side.
Okay. And were there any, I guess, defects in the front of the vehicle?
Don't think so, no, sir.
And is the defects being found in the back of the vehicle consistent with the vehicle being backed in or parked with the back end closest to the breezeway and the front end kind of closest to the access road?
Your Honor, I'm objecting to this is speculation.
Well, he said consistent with, overruled.
The damage that I saw was consistent with it being attacked from the rear and from the driver's side.
One moment, Your Honor. No, I'm further at this time.
Be very quick, Your Honor.
Go ahead.
Detective, when you were speaking with Mr. Mitchell and Mr. Uten, you were trying to figure out if they had any idea why the shooting would have occurred, correct?
Yes.
And you addressed with them whether either of them had stolen anything, right?
Overruled.
I did.
Okay. And you had no indication that that would have been the reason here, right?
I tried to figure out with Mr. Mitchell especially of the motive for what happened. Wasn't successful in speaking to him about that.
And Ms. Smith's statement about Mr. Ryan having stolen a gun, what did you do to vet that statement?
Mr. Mitchell stole a gun.
I'm sorry. My apologies. What did you do to vet that statement?
Nothing.
You said no?
I didn't vet it.
Okay.
Just took it.
Mr. Abate asked you about whether after Ms. Smith began talking about two shooters, whether she remained consistent about that. And you had no reason to press her and suggest otherwise, right? Because that was your theory, right?
That's correct, yes.
Okay, thank you.
All right. Thank you for your time. Well, I guess I shouldn't have assumed that no other defense attorneys had recross. All right. I just happened to be correct. Okay. All right. Thank you for your time. You're excused.
Thank you, Judge.
And this seems like a good time to break for lunch. So we will break for lunch until, I think we've probably got some work to do during lunch. So I'm going to give the jurors until 1:30. All right, we need to deal with the Wooney Lee evidence. How long do you think that's going to take?
It should only take about 15.
All right, why don't we just do that before we break then? And I'm sorry, did y'all get to the point of forwarding
Yes.
the document
Did I forward it to you, Ms. Percival? Yes.
this morning? Yep, there it is. Okay. All right, so I've got that open, so if you can start directing me to which items are at issue. This is an, okay, Instagram. Is that right?
Yes, Your Honor. And I'll say most of the items in this packet will probably only come in if I have to impeach Mr. Lee. So we can definitely go through it, but just to set the stage, Your Honor, about what the items in here are.
Okay, so is everything that's in here we need to litigate? Is that what it is?
Yes.
Okay.
I'll begin pages 1 and 2. So let's start with 1. Page 1 appears to be a conversation. Mr. Lee is the slimelife.shoddy. This is a conversation where he says, get somebody to buy my Switch. The next page is a photo of a firearm. I'm not sure how that suggests any sort of illegal activity whatsoever.
Your Honor, the fact that he has access to a switch in and of itself is illegal to have a switch for a firearm, Your Honor.
Have y'all charged him with that?
No, Your Honor. And for the first page, he has not been charged with the switch. And so we won't enter in page 1. Page 2 or page 3, Your Honor, which is Mr. Lee with a firearm, Your Honor. Again,
Are you talking about the hand?
the hand, yes.
Can you establish that that's him?
It's his Instagram record, Your Honor, and it's something that I would ask.
No. If that's the best you can do, that's just a picture of somebody's hand holding a firearm, so that is not going to be permitted. Unless you ask him, is that your hand? And he says yes.
And that's why I started trying that most of this is for impeachment, because it would depend on the questions that I ask of him, whether or not this becomes relevant. So that's why I started.
I mean, I guess you can present him with it if you for some reason are able to ask him, did he ever have a switch? And he says no, you can, without showing the jury, present this. And if he says, oh yeah, that's me, then we've got one thing, but okay. Moving on to the next item.
Page 3, Your Honor. I don't know how Mr. Lee is involved in this. I don't see his screen name on here, so I don't.
I'm not sure which page you're calling, page 3.
Well, the third page of this document, which is page 17 and or page 2313.
Yeah, we're withdrawing this page.
Okay.
Page 2314 is a photo of, this time it's a leg with a gun.
Your Honor, it would be the same position as the first
right.
one.
Next.
The next one, page 5, which is the top Instagram page number 24836. The majority of this conversation is from author F-O-E-V-A-K-T. That would be hearsay. I'm not sure under what theory it would be admissible. It seems to be talking about business and a song.
Your Honor, we're going to withdraw this one.
All right. How about page 6?
I would defer to other attorneys if they have any objection to page 6.
Your Honor, I object unless there's a better or some foundation. I heard what the prosecutor said, that they would not attempt to use it unless they lay a foundation or impeachment. But I don't know who these speakers are, except I assume that SlimeLife.Shawty, S-H-A-W-T-Y, is the witness. But other than that,
Right.
I would object. I don't know if it falls under any type of hearsay exception.
The first post on June 4th of 2019, the witness who's testifying says the YFN expletives are at your house. And then a couple lines later, he says, just stay out of their way, bro. Too much going on. I'll come light that bitch up if they play with you. So considering that we put testimony in about the mother of Mr. Bennett's home, who is a member of that same YFN group that was shot twice, we've been discussing this back and forth rivalry quite extensively. So the fact that he's talking about explicitly stating the YFN group and he's going to come light it up in reference to shooting either at or towards those people, I think it's quite relevant, and he's testifying in the stand. So any questions or explanation he wants to give for that, he most certainly can.
So what about the other part of the conversation, though? Are you not offering that part? Going to redact that part?
So, Your Honor, this is a back and forth conversation that he has with this other individual. And so I don't know what specifically, I mean, the bottom three, I don't know what specific line that defense is stating is not needed for the context of what Mr. Lee stated here.
Well, certainly the last bit of it isn't needed, but I mean, not since all that X has been happening, we don't know who this is, and that is indicative that stuff's been going down.
Yes, Your Honor. And the state, what I just read and what's highlighted is what the state, that's why we included this.
Okay, and I'm asking if you're going to redact it, because if you throw that up on the screen, I know that the highlighted part is what you're highlighting, but the rest of it is easily visible.
Yes,
so
Your
are you
Honor.
going to redact?
We can redact it and keep that just the username so it doesn't appear that he's just speaking to himself.
Okay.
And we will take out where he says, everything else he says. That's perfectly fine, Your Honor.
All right. Page 7.
Yes, Your Honor, page 7, this is going to be a combination. We have a hearsay within hearsay. We have Mr. Lee asking who Fat was talking to. Not sure the relevance, because I don't know who Fat is. They might ask questions which make it relevant, different conversation. But the response from someone who's not testifying is what that person heard. So we have hearsay within hearsay. The next statement is also from this other person who I'm not familiar with who the speaker is. Mr. Lee's response is ambivalent, just say no more. And there's not any further conversation that I see would be relevant.
What's the state's response?
So, Your Honor, this specific exchange, it's very predicated on what Mr. Lee his response is on the stand. If he says, just like the post I just referenced before, if he says, I've never heard of YFN, I have no problems with them, I'm actually quite friendly with them, they're not opposition to me, I hang out with them weekly, then these kind of threads could become relevant, where they're saying, I just heard he was with Slime, he told him he was with YFN, and then the person, again, not Mr. Lee testifying, says that those people are ops, and then he responds, say no more. That in conjunction with like the one we just spoke about, I don't know the exact question we would ask Mr. Lee, but none of these conversations, if an improper question is asked and the court sustains the objection, you will never have the predicate foundation to introduce this. And so I do think it hinges very much on how his testimony
I think
is,
that
Your
before
Honor.
you think it's appropriate to use this, y'all need to approach, because I am having a hard time envisioning how
Yes, Your
this
Honor.
would be appropriately used.
Yes, Your Honor.
Okay.
The next page, Your Honor, is going to be page 8, and a conversation between Slat Quay and Mr. Lee. Again, I think we have hearsay. We don't know who Slat Quay is or what his possible involvement could be. They're talking, it sounds like, about something which happened in the past. I'm not sure how that would come in as any hearsay. It would be, if anything, spilling the beans, not furthering the interests of a gang. If that's even the exception they're trying to use, I don't know.
You're right. I think that falls in the same line of argument that this conversation would fall into that same line of what Mr. Atkins just articulated. Your Honor. Page 29, Your Honor, would be, I think, in line with the same articulation that Mr. Atkins just did for the page before. It's the same individual. It's the same conversation. The same two people in conversation.
It would be to potentially establish that, yes, he did know who YFN were, and that was significant to him in some way.
Yes, Your Honor.
Well, that's potentially a better example of it than the one above. Talk into your mic. Talk into your mic and talk to me.
Was talking to you, Your Honor.
Okay. Because you're gesturing over at them.
I know, but I believe this is what I referred to the other day with regard to the person that is identified as Slat Qua, not Quay, but it's Slat Qua. One has not been identified, but it is certainly no one in this courtroom, and I believe that the state will elicit that. This is my understanding, and I'm looking at you, Judge. It's my understanding that that would be the testimony. If there is anything else, I want an opportunity to.
It was my understanding that the state and the defense were going to enter into a stipulation that any reference to a qua here or wherever it comes in this Instagram, there was a stipulation that it wasn't any of the people nicknamed Qua or Quay in this courtroom. Have y'all not done that?
Judge, that's been my understanding as well. However,
we're still working on that.
All right, well, sounds like we might need to get to it before Wooney Lee testifies.
I agree.
Your Honor, myself and Mr. Harvey had spoken a short while ago where asking this witness, I mean, this is his thread of who is this, and then I do not know what his response will be at this moment, but I do not expect him to say it is Mr. Nichols or Mr. Huey, and whoever he says, if he says, I don't know who that is, you can ask him, is there anyone in this courtroom here today? And if he says no, I think it will be crystal clear that that was what me and Harvey were, we hadn't finalized it, but that was what we were discussing. The state's not trying to insinuate
discuss it with Mr. Matthews also.
Yes. Yes, Your Honor.
If y'all come to an agreement, that's fine.
Your Honor, I will.
And why don't you let me know what that agreement is before Mr. Lee testifies?
Your Honor, Mr. Rubin, Mr. Lee's attorney is here. I will ask Mr. Rubin, and we'll have that answer before lunch, by the time we come back from lunch.
And Your
Going
Honor,
to ask the attorney what the answer to that question is.
So he
gonna
can
be?
ask his client, that's Mr. Lee's attorney, so we can get the answer of who Slack Quay is over the break.
Okay, and then what if he says one thing to his attorney now and then he says another thing on the stand? Are we going to have another specter of putting an attorney on the stand?
No, Your Honor. I believe that we have been in communication with each other. So I don't think that result
I'm
will
not sure
occur.
that that's going to resolve it, but if the state and Mr. Matthews and Mr. Harvey come to an agreement about that, that's fine. Y'all let me know.
We will.
Okay. Next.
Your Honor.
So is there another objection besides we need to make sure that everybody knows who this is or isn't the Slack Qua?
I do, unless it's
Okay.
coming in under 248807 D2E. All that Mr. Lee, according to this document on page, all he says is you all got into it with them. Everything else would come from this other person, so that's my objection as well. That page really is not very illuminating on what Mr. Lee is doing to further the interests of the alleged conspiracy.
So it would be, as I understand the state's position, it would come in to impeach Mr. Lee if he claims not to know who YFN is. Is that correct?
Yes, Your Honor.
Okay. And so do you need the entirety of it?
On a different page anyway.
This is, I'm looking at page 1397, the highlighted portions of 1397.
To the court on page 854, which I think is 2 pages forward or above. It's Mr. Lee. It's identified as Mr. Lee's Instagram account, and it says YFN ends be by you house. So I don't see why we would need it set, on another page.
A different one. Oh, that's true. Okay, so.
The state's position remains the same. This will become relevant depending upon the question. So this might not come in at all. And so what would the court like for us to answer?
So if there is already something in, Mr. Steele makes the point that you actually have Mr. Lee on page 854 of the Instagram record talking about them YFN ends. And so that would establish that he knows who they are, and so you don't need the others. So that's true.
All right.
And if you think for some reason one of those others is going to be relevant, again, you're going to need to approach before you use it.
Yes, Your Honor.
Because it shouldn't be needed for the reason that y'all just offered, considering page, whatever it was, 854. Okay? All right. And then what is this? What's on page 9?
I'll defer to Mr. Steele for the remainder.
All right.
It looks like there are notes, internal notes written over the document. I would not want that shown to the jury.
Yes.
We don't intend to introduce these notes. We're actually going to pull the actual thread, and I believe that was communicated in the email that we sent. But for brevity's sake, we wanted to show defense counsel where the language we're speaking of, but this is actually in Mr. Lee's Instagram return, so we'll find the actual, we'll have the actual pages of.
But what we need to be looking at is just the thread.
Yes, Your Honor.
Okay. And is there objection to the thread?
No, Your Honor.
Okay. All right.
If a proper foundation could be
All right, and then I just got another email forwarded about Wooney Lee exhibits. These are pictures, maybe, posts from somewhere. Is there issue about these? Do we need to litigate these? Do y'all know what I'm talking about? States 36, 37 through, I don't know.
This is just a PowerPoint of the exhibits we plan to introduce during Mr. Lee's testimony, Your Honor.
All right, is there an issue, is there an evidentiary objection to 36 through 46, NN, and then 4Y?
And most of these, Your Honor, were in the Wooney Lee folder that we went over a few weeks ago.
Yeah, I mean, if we've already litigated it, great. I'm just asking so we don't.
We didn't litigate it a few weeks ago, but as far as 36 NN, 37 NN, and 47 NN, those are the issues that I brought up on behalf of Mr. Stillwell. Those involve Mr. Stillwell, and I brought them up yesterday morning.
Okay.
But as far as anyone else is concerned, these are not things that have been litigated, except the ones that I brought up yesterday.
Okay. So, does anybody else have any objection to any of these items?
Your Honor, I was proceeding on the state's email, which was sent two days ago. This is what we need to review for Wooney Lee, so I've not had a chance to go through all of these.
Y'all are just too much, honestly, all of you, or most of you, not all of you, but a lot of you.
Your Honor, to be clear, so when we made the witness boxes from 1 through 30, 31 through 60, and 61 through 100, for the, there may be a photo here that, you forgot to put into this witnesses folder, but all from discovery. So when we're creating these, like the exhibit PowerPoint, some of it includes exhibits that are already admitted in the trial itself. It's literally the PowerPoint in order of how the state's going to ask direct questions of this witness. So there shouldn't be any surprises with what's in this PowerPoint in terms of, I don't know what day or week it was that we went through, but I know that there was a moment where we got through all of them, where the court would say, does anyone have any objections with this witness? Does anyone have any objections with Mr. Sprinkle, with Agent Burney? And we went through number by number, and of course, if an objection is raised, this honorable court will hear it from any party. But, when we say we haven't litigated or have litigated, in the state's minds, when these issues are brought up, does anyone have an objection on the floor for this witness and the exhibits the state has indicated that they may use with that witness? If there's no response,
All right, well, take the lunch break and look and see if you have objection, and can come back at 1:15. Yes.
And I can speak to one, just so everyone knows. I know I have an objection now. I didn't realize it was in this PowerPoint, but it was something that was recently, the state recently indicated that they plan to use, which is number 12. That's a screenshot.
I don't know what you mean by number 12.
Number 12 on the PowerPoint. It's
46.
Slide 12.
Okay.
46
NN.
And that's just a screenshot. I believe that to be a screenshot of the beginning of a 15-minute video. And I believe that video is titled something like A Night with YSL and 4L. I've watched that video. I've reviewed the video. It's basically a group of young men at a music studio and in the parking lot outside the music studio, and they're kind of interviewing each other, and I guess it was released as a promotional type thing. But I don't know why that 15-minute video would be relevant or admissible.
Yes. I can email over the different timestamps that are the most relevant portions of this video. It's not the entirety of the 15 minutes, and I'll do that before I leave court.
So are you saying you are only planning to play
certain portions of the video?
certain little distinct parts of it?
Yes. And I'll send that over right now.
Okay, do that right now, and then when we come back at 1:10, now we can take it up.
Definitely not making my birthday lunch.
No, I'm not. No. All right, so anything else we're gonna need to deal with? Oh, so the limiting instruction, if nobody has anything else to add, does anybody have anything else to add on that limiting instruction that I'll read before Mr. Ryan's conviction is entered?
Well, I don't know as to whether we made a number 1 or number 2 decision.
Yeah, I decided it on my own because nobody got back to me. I picked number 1.
That probably
So-
would have been my pick, but I just
All right,
I want to reiterate, though, that I agree with Mr. Steele's position that ultimately neither one of them eliminate the confusion from, boy, we can use some of this against some of the people, but we can't use some of this against some of the people. So I want to reiterate that and just reinforce that as well.
All right, so I have, at this point, I mean, I can send it back out, but let me just do that real fast. And I haven't changed anything with regard to, let's at this point just focus on the Mr. Ryan one. Let me get that over to Ms. Pursfield so she can get it over to y'all. But I've taken out the reference to overt acts numbers or overt acts at all. Because when I started trying to craft something that would explain, hey, this is to overt acts, but that's not all you have to, find if you're going to find, when you're making your determination on count 1, I realized that it is not really just to overt acts anyway, that it could be taken into consideration in their determination of whether they think anybody was conspiring to engage in a pattern of racketeering activity. And that just goes down a whole, I don't know, wormhole, black hole, I don't know what, of having to stop and give the final jury instructions now, which I'm not going to do. So I'm just saying, count 1. Yes,
Your
sir.
Honor, on behalf of Mr. Stillwell, we appreciate the court's efforts, and this is a difficult situation, and we are just, for the record, joining with the thoughts of Mr. Steele and with Mr. Harvey that a jury instruction is not going to be not enough. But I just wanted to place that on the record.
I mean, I assume everybody's joining in that objection, and that's fine. I've looked at a lot of different federal circuit case law involving RICO cases, and it appears that even when a conviction of a co-conspirator comes in, as long as a limiting instruction is given, there's not a confrontation clause problem.
And I just feel the need to bring this up at some point sooner rather than later. There are convictions of Mr. Jimmy Winfrey, my client, Mr. Stillwell, and I believe Mr. Nichols that have come into evidence.
Right.
We brought up these issues previously with the prior judge, and we were not given. We asked for them not to come in. We asked for limiting instruction, and we were not granted those things. So I don't know how we're going to cure that for those.
So I mean, I thought that we had discussed the Winfrey one, and I said I would just at the end, when I remind them of all of the things that are only for certain purposes, do that. I didn't know that anything of Mr. Stillwell's had already come in without a limiter.
They have, and I believe Mr. Nichols as well.
Okay. All right. Well, then I will add those two to the Limiter I'll get at the end. And again, they're not supposed to be deliberating until the end anyway.
Okay, so when you're saying at the end, you're talking about jury instructions.
My jury instructions, yes. All right. See y'all in a fairly short amount of time.